Well, good afternoon here at Kaplan Morrell, and I'm with,
Angelica.
I knew her name.
Oh,
I
and
promise.
Oliver.
And Oliver. And we've only brought Oliver in because market research tells us that posts with Oliver do 82% better than posts with just me. So Oliver apparently is famous,
Yes.
viral, and Oliver is our legal beagle here at Kaplan Morrell. And he has a tie. Show him the tie. So in case you think that his presence detracts from our professionalism, that's not the case. So we're going to speak about 5 minutes on what kind of questions we ask folks who call our office, injured workers, and why we ask them, and that can kind of help you understand what may be happening, that if it's happening to you, then you know you need an attorney, which is almost all the time, I think. But anyway, so chances are if you call the office and you're an injured worker, you're going to speak with
Angelica, yes.
Is it Angelica or Angelica? Am I the only gente here?
You're the only gente here,
Okay,
that's why.
I'm only, okay. Angelica. Okay, so Angelica, let's talk about 4 questions that you ask injured workers that are kind of strange.
Kind of strange?
Yeah, I mean, like, obviously we ask them their name, their telephone number, and stuff like that.
We like to ask the body part that they injured, how they were injured, when they were injured.
Okay, so let's talk about when they were injured. So sometimes people get the mistaken impression that if they don't report their injury, if they don't file a claim, there's this kind of obscure part of the rule which says that you have to report your injury in writing to your employer within 4 days of the injury, or blah blah blah. And sometimes injured workers think, oh, if I don't report it in writing to my employer in 4 days, then I'm SOL. Not true. Obviously, it's best to give your employer written notice of the injury as soon as you can. And the reason primarily for that is that we're looking to see, we had a phone call. I had it on Do Not Disturb, and it was my son calling from the Navy, but not yet. Anyway, so we try to get proof that the employer knows about the injury, because if we have someone calling us and their employer can still claim they don't know about the injury, it makes the case a little tougher. Also, date of injury is important because sometimes there's what's called a 2-year statute of limitations to file a claim. So if we're talking with somebody and their injury was 2 years ago, we have to look at it carefully to see if there is maybe a final admission that's closed the claim, or if they haven't reported it and it's been more than 2 years, are we going to be able to pursue it? So if it's been more than 2 years since your injury, or if you're approaching that, talk with us. Okay. Next questions that we ask.
We also ask,
I know.
I
I just pulled you here unannounced. You have no idea, and you only do this constantly every day. Now
I only
you can't
do this
remember.
every day, and I don't remember the questions. We also ask where you were employed, for how long, what your position with them was.
Okay.
We ask
how long you were employed helps us, because many of your benefits are determined on your average weekly wage, and we like to know how long we need wage records. Also, it's not a bar to a workers' compensation claim, but it can make it more difficult if you just got hired and the day you got hired. I mean, I actually had somebody who was injured the first week of their employment. They were not happy about that, but we got them benefits. So what else?
We also ask about medical appointments, whether they're treating
Why do we ask that?
Comp or on their own. There's some people that start treating with their own primary care physician, so we ask that as well.
And we ask that because there are certain clinics, occupational medicine clinics, that people will only go to if they've been told to go to them, because the insurance company or the employer has directed them. And so if you are treating, for example, at Concentra, that's just our opinion. We're not expressing a fact. for libel purposes, correct?
Yes.
There's only one reason you go to Concentra for medical care, and that's because your employer told you to, the insurance company told you to. But if you're going to Concentra, that tells us a lot of things. That tells us your employer knows about the injury, the insurance company knows about it, the injury, more likely than not it's admitted,
Right.
etc. But if you're treating with your own doctor, your personal care physician, then that starts to open up other possibilities, like maybe it's not an admitted claim, maybe your employer doesn't know about it, etc.
We also ask about what the initial treatment was, whether or not your employer sent you to the hospital, either it was an emergency visit or via ambulance, or somebody took you. We ask that as well.
We ask, when was the last medical appointment?
Yes.
Why is that important?
Because there's some people that have, the last appointment was their a maximum medical improvement
She's
appointment.
such a rock star. She knows all of this stuff by heart.
So if they've been placed at MMI, let's say 2 months ago, then we're expecting that there should be an FAL, final admission of liability, and that's very important because it's time sensitive. So.
Right, and so we ask, when was the last medical appointment? Because if someone says, well, it was, 30 days ago, 40 days ago, then that keys us into the fact that the insurance company may be in the process of closing the claim. We have to start asking some questions. Oftentimes we'll get the Division of Workers' Compensation on the phone, because typically within 30 to 45 days after your last medical appointment, the insurance company is trying to close the claim. And if you don't do certain things within the receipt of that final admission, it doesn't matter if you signed off, it doesn't matter if you cashed a check or whatever, it doesn't matter if you didn't get a check. If you don't do certain things, then your claim is closed and you are stuck with what the insurance company gave you. So again, if the doctors have said there's no further care, there's no further treatment, you're done, and it's been, do not wait and give us a call, because that means that pretty soon your insurance company is going to be trying to close your claim. Right. We also ask, what else, about lost wages, right?
We do, yes.
What do we ask?
What their pay was, whether it was salary, hourly, and how many hours they worked. Yes.
And whether or not they had lost time?
Yes, whether or not they have lost time from work.
And if they had lost time, are they getting checks from the insurance company?
Right, that's right.
And if they say yes, then what does that tell us?
If that says yes, is they've been, it's more likely to be an admitted claim.
And if it's an admitted claim, then we know that we have to worry about other things versus if it's not an admitted claim.
Yes.
So, and then we also check with the division to see what's filed with division.
That's correct. Yes, we ask certain questions to the division as well.
Yeah. So just understand that when you call an attorney's office and you talk with someone as sweet and as caring as Angelica, aka Angelica.
Yes.
She's going to be asking you a lot of questions that's going to help us make sure that we help you, that we assign you to the correct attorney, that we have a good idea of what the issues are, but more importantly, we know if there are certain things that are happening which may require us to really jump in quick because there are deadlines ticking. And so, as always, we ask that if you or someone you know and love have been injured on the job in Colorado, that you give us a call. We offer free consultations. Our telephone number is 970-356-9898. And if you're injured on the job and you call us, guess what? You get to talk with
me, Angelica.
That's right. All right. Well, thanks so much. And again, have a great weekend. Bye.
Thank you.